Hey everyone! Imagine a marriage that once flourished, now reduced to a battlefield of numbers and accusations. Today, we dive deep into a case that unveils a bitter struggle over hidden wealth, financial secrecy, and the law's attempt to find balance in the chaos of divorce. This is the story of XIK and XIL, a judgment released last week. Divorce is never just about lost love. It's about the battles that follow, the division of wealth, the fight for financial security, and sometimes the suspicion that one spouse is hiding money. But what happens when the law steps in? What happens when the court has to decide, is someone actually hiding assets or is it all just an illusion? Today, we are discussing a high-stakes divorce case from Singapore where a wife accused her husband of dissipating assets and hiding wealth. Let's break down the case, analyze the legal principles involved, and explore what it really means when the court is asked to draw an adverse inference. The husband and wife were in a long-term marriage before things fell apart. As divorce proceedings commenced, they were left with one final challenge: how to divide the matrimonial assets fairly. The wife alleged that the husband had dissipated assets, meaning he had hidden or spent away funds that should rightfully be part of the matrimonial pool. The wife's suspicion that the husband secretly held cryptocurrency assets, underreported the value of his business shares, and used business dealings to funnel away money. The question before the court: should an adverse inference be drawn against the husband? In other words, should the court assume that he was hiding assets simply because he was not fully forthcoming? The stakes were high. If the court found against the husband, the missing assets would be added back to the matrimonial pool, affecting the final division of wealth. A closer look at the wife's claims reveals several areas of concern. She pointed to the husband's transfers of a total of $12,100 to purchase Ethereum after the divorce process had begun, allegedly for his brother, but with no concrete evidence that the funds were no longer in his control. She also highlighted that the husband initially claimed that his shares in Company H had no value, only for it to be discovered later that they were worth millions after the company's listing and IPO. Further, she raised concerns about her husband's directorships and shareholdings in companies in Papua New Guinea, arguing that these businesses could be vehicles for financial concealment. Finally, she pointed out discrepancies in his financial records, including a trip to Brisbane that had no recorded personal expenses, fueling suspicion that he had alternative funding sources. The husband, on the other hand, refuted these allegations. He insisted that he had fully disclosed his financial dealings and that the cryptocurrency transactions were made on behalf of his brother. He argued that the fluctuation in the value of his shares was normal and that he had promptly updated the court once they gained value. As for his Papua New Guinea business interests, he maintained that most of these companies were either dormant or deregistered, with no hidden assets or revenue streams. The husband also explained that his employer had covered his business-related expenses, which explained why there were no personal charges recorded for his trip to Brisbane. With two conflicting narratives before it, the court had to determine whether wealth was deliberately concealed. Precedent cases such as TNL and TNK, which I covered in another video, established that large expenditures during divorce proceedings could be added back unless consent was given. While in the case of UZN and UZM in 2021, reaffirmed that mere suspicion of concealment is not enough. After examining the evidence, the court ruled that the husband's Ethereum purchases were substantial and unauthorized, warranting the addition of $12,100 back into the matrimonial pool of assets. However, regarding the Company H shares, the court found that since the husband had eventually disclosed them, albeit later than ideal, there was no basis for drawing an adverse inference. Similarly, there was no sufficient evidence to prove that the husband's Papua New Guinea business interests held hidden value, and his company-covered expenses were found to be legitimate. While some funds were added back to the matrimonial pool of assets due to a lack of consent, the court did not assume that the husband was hiding significant wealth. This case reminds us of a deeper truth: the suffering that comes from clinging to wealth. The husband fought to protect what he saw as his, but in the end, the court ruled based on facts, not emotions, not assumptions. Attachment blinds us. We see what we want to see. We grasp at what is slipping away. But as with all things, wealth is impermanent. True peace comes when we learn to let go. In law, as in life, clarity comes not from suspicion, but from truth. The moment we let go of illusions, we truly see things as they are. Courts need evidence, not just suspicion. Spouses should disclose assets properly. Late disclosure is not non-disclosure. Holding on too tightly, whether to money or grudges, only leads to suffering. Thanks for joining me in this case summary. Don't forget to like, share, subscribe. I'll see you in the next video.